Well, Eurojust's job is to coordinate Europe's fight against serious cross-border crime, and it does that by bringing together prosecutors, judges, police officers, experts from the member states, and we all work together in premises in The Hague, in the Netherlands, discussing and taking forward cases which have been referred to us. The basic structure is that each member state seconds as I say, a prosecutor, a judge or a police officer to come to work at Eurojust and to deal with cases which have been referred by member state investigating authorities and prosecuting authorities, and to see what can be done at a European Union level to ensure that criminals are not able to escape justice simply by moving around the European Union. We work in a very straightforward and simple, but in my view, effective way. Perhaps if I could describe a case history, it's not a real example. Let's say that a prosecutor in one member state, in Estonia, has a case on his desk. It's a drug trafficking case, and it quickly becomes apparent from the information which has been gathered that the drug trafficking operation in Estonia in fact has links to drug trafficking in other member states of the European Union. Now, the prosecutor in Tallinn is going to be faced with a problem. How is he going to be able to fight a drug trafficking ring which is working in London, in Brussels, in Paris, in Rome, in Warsaw, all throughout the European Union? He doesn't speak all the relevant languages. He won't have the relevant information about what measures are available in national legislation to fight drug trafficking in another jurisdiction. But if he picks up the phone or sends an email to his representative at Eurojust, then that person can take forward the case by organising, in the usual Eurojust procedure, organising what we call a coordination meeting. Cases will be referred to us from these different authorities. To go back to the Estonian example, the Estonian prosecutor contacts his contact in Eurojust. The Estonian national member, as they're called here at Eurojust, will then call a meeting of all the relevant parties. So if the drug trafficking operation they are fighting has links in 4 or 5 member states, he will speak to his colleagues on those in those respective jurisdictions, all of whom, of course, are based here in Eurojust in The Hague, and it'll be decided to call a meeting. And at these meetings, what Eurojust offers is a forum in which prosecutors and police officers from different jurisdictions can speak to each other, and they will have the expert input from Eurojust staff and representatives who are specially expert in the fields of judicial cooperation in cross-border cases. There may well also be contributions from our partners such as Europol or Olaf, as I mentioned. So people join round a table. We provide very high-tech translation and interpretation services for the meeting, and so it can be discussed and decided at one meeting in The Hague. All relevant parties round a table can decide, yes, we need to take action against this drug trafficking ring. We are going to hit this drug trafficking ring in 4 or 5 different member states on one particular day, and to support that we're going to ensure that European arrest warrants, for example, are issued all at the same time. We're going to ensure that bank accounts are frozen all at the same time. We're going to ensure that house searches and arrests all take place at the same time. So there's a lot of coordination and logistical work which is undertaken by Eurojust in a case of that nature. what will happen will be that after the coordination meeting there will be a series of recommendations and decisions taken in that coordination meeting, and then it will be for the member state representatives to go back and ensure that, for example, the Estonian authorities have details of where the bank accounts are, of who is using the mobile phone which has appeared on the Estonian file, of where the defendants who are to be arrested are actually located at a particular time. Where are they going to be on a particular day, in order that all actions can be coordinated and take place effectively. Under the Treaty of Lisbon, Eurojust has the mission of supporting, of what's described as supporting and strengthening national investigating and prosecuting bodies in their work, especially obviously in cross-border cases. Eurojust at present does not have any powers to order an arrest, for example. There's a qualification to that. Some members of Eurojust do have the powers to issue, for example, a European arrest warrant, because that is a power which they have in their home member state. And so when they're seconded from their member state to Eurojust, they retain those powers to issue, for example, arrest warrants or to authorize controlled deliveries, things of that nature. In general terms, we deal with about 1,500 cases a year at Eurojust, between 1,400 and 1,500 cases in a year. And that, and we're coming up for our 10th anniversary, our 10th birthday next year, and there's been quite a marked increase in the number of cases which have been referred to us by member state authorities and by Europol and Olaf. So if you look back at 2002, when Eurojust was first established, there were only, say, 200 cases. Last year, 2010, we had something, as I say, in the region of 1,400 cases. So you've seen an increase of 7 times in the number of cases which we deal with. And there's also been a significant increase in the number of these coordination meetings, which I described earlier, when we bring together experts from the member states together with experts from Eurojust and work out how the cases are going to be taken forward. The Treaty of Lisbon, or in its format as the Treaty on the Functioning of the European Union, has two central articles so far as the future of Eurojust is concerned. The first is Article 85, and that article says that there can be or there shall be, in fact, a regulation on the future of Eurojust. And the regulation on the future of Eurojust can consider different matters. It can consider the structure of Eurojust, how Eurojust is basically organised, and it can also consider substantive powers for Eurojust. Should Eurojust, for example, be given a power to start investigations? That's one thing which is actually written into the Treaty of Lisbon. Should Eurojust have the power to order a member state to take forward a particular investigation or prosecution? Because what you do have under in cross-border cases is what we describe as conflicts of jurisdiction. The other big important article for the future of Eurojust is Article 86 of the Treaty of Lisbon, and that provides that there may be, following a legislation at European Union level, there may be a European Public Prosecutor's Office created, and the treaty says explicitly, from Eurojust. Books have been written about what "from" Eurojust means. So the word "from" is a very complex word in these terms. But in the immediate future, there is going to be, I think, a legislative proposal for the future of Eurojust, and in particular its structure under Article 85. And there well may be, I think, in 2013, a proposal for a regulation on the creation of a European Public Prosecutor's Office from Eurojust as well. But these are very delicate and sensitive matters, as you can imagine. First of all, we have moved from 15 member states in 2002 to 27 member states as we currently are. But I think underlying this increase is not just the increase in the size of the European Union. What really underlines it is the realization that cross-border crime is growing. There have been all sorts of benefits from the relaxation of internal controls within the European Union, but that has meant that it is also easier for criminals to move from jurisdiction to jurisdiction. And it's really, I think, the raison d'etre of Eurojust to ensure that criminals are not able to escape justice merely by the fact that they're able to cross borders easily. And that, I think, underlines the real increase in Eurojust referrals from member states, because they are faced increasingly with cases of that nature. It's so easy for everybody these days to jump on a plane, to jump on a train, to get on a ship and go to another jurisdiction and continue perhaps criminal activity there. There have been two decisions at European Union level about Eurojust. Firstly, when Eurojust was created in 2002, and subsequently when a new revised version of that decision was published in the official journal in 2009. And the key element for me, at any event, in the revised Eurojust decision is that it creates an obligation on member state authorities to send information about their important cross-border cases to Eurojust. And so if you're saying what is going to be the future of Eurojust, how can Eurojust really add value to the fight against serious crime in the European Union, it's by receiving information from member states. And that, if you like, is the starting point, I think, for the improvement to the future of Eurojust, and to ensuring that we actually do provide added value to member states in their fight against organised crime. We do have a wide range of cases referred to us. Clearly, they have to reach a certain level of gravity, but it is almost, but as I say, I would estimate something in the region of 30% of our cases come from fraud. Approximately 30% of our cases come from drug trafficking, and then there are all sorts of different crimes which are also dealt with at Eurojust. And what we do, in fact, so far as the cases which are referred to us, we prioritise those cases which have been identified by the European Union as posing a particular threat to the citizens of the European Union. And so we deal, if you like, what are often called Euro crimes. Those are the crimes which have been identified in the Treaty of Lisbon as posing a particular threat to our citizens throughout the Union. The legislators in the Treaty of Lisbon have first of all decided that the protection of the financial interests of the European Union is important, and I think to some extent the reasoning for that is that it's very, unfortunately, it can happen that people will think, well, if a fraud occurs and it's the budget of the European Union which is being affected, then somehow it's distant. It's not as if your own immediate budget is being affected. It's something which is somehow administered away from you. There's a distance on the responsibility for protecting that budget, and so the legislators in the Treaty of Lisbon have thought that if it's necessary to create a European Public Prosecutor's Office, then the first area to which the Public Prosecutor's Office should concentrate is this protection of financial interests of the Union. Let's say that an official in Brussels, in the Commission, has responsibility for awarding contracts. And in this particular instance, the official awards a contract, but on the basis that he receives a corrupt payment. It may be the case that you will have, for example, the official who is working there is not, although he works in Brussels, he is not from Belgium. He may be from any one of the 27 member states. He is dealing with a company to which he awards the contract, which is not Belgian, but also based in one of the 27 member states. And although the head office of that company is based in member state A, perhaps they actually have their sphere of activity, so far as this contract is concerned, in member state B. And at the same time, the money which is being corruptly received is funneled or channeled through member state D and then goes to member state E. And what you have in that simple instance of corruption is a number of jurisdictions, all of which could claim to have jurisdiction, and perhaps, unfortunately, none of which actually want to take on the investigation. And as I say, in those circumstances, that's where organisations like Eurojust can play an important role in adding value to the investigations which have been undertaken at that level. But perhaps I could just finish by one example from a real example from our casework, which was in fact global in nature. It all started when a paedophile was arrested in a state outside the European Union, in this particular case in Norway. He was arrested for an offence against a young child in Oslo. But when the police in Norway went to his house, they found a computer which showed that he had links relating to his paedophile activity throughout the world. There were links to the United States. There were links to countries as far away to Pakistan, to Afghanistan, to Brazil, to Australia. There was effectively a paedophile network of which he was part. That immediately caused problems in the sense that clearly the Norwegian authorities wanted to take that forward, but fortunately they came to Eurojust because we have, in addition to the representatives of the 27 member states of the European Union, we also have liaison prosecutors from outside the European Union. So in this case, the liaison prosecutor from Norway was contacted, and it was then possible to actually bring together and undertake a global operation to shut down this paedophile ring, which communicated via the internet, and that led to many children being saved from abuse, because sadly what was often happening on the internet was that a paedophile in one country was telling a paedophile in another country where he could locate children, how he could actually start grooming the children, and so they were exchanging advice and tips on how they could exploit vulnerable children in this way. And the advantage of Eurojust, as I say, was to bring together all the disparate investigations and ensure that this ring could be shut down in one effective operation. And without having a control centre, if you like, using the word widely, without having some kind of centre like Eurojust to coordinate all that information, all those actions, many paedophiles could have continued with their activity and ruined the lives of many vulnerable children.